Illegitimate contracts. We have our points that make a contract valid, but let's kind of dive into what makes a contract illegitimate. We've got certain points that are void or voidable. So that's a big difference here. We'll see as well. So a contract, if a contract's void, that means no matter what, it's done. It's canceled. It's over. However, if it's voidable, that means one party or both parties or many different instances we'll see have the option of eliminating the contract, of making it void. So again, if something is automatically void, the contract's done. It's over. There's no negotiation. However, if a contract becomes voidable, you can make the contract void. So there's an important distinction there. We've got various factors that work to undermine their enforceability or validity. The following issues can render a contract illegitimate. First off, if there's any fraud at all involved, if there's proven fraud, obviously you got to go through the courts. If there's misrepresentation in the contract, any aiding and abetting, if there's an intent to deceive someone, if there are any damages done, and if there's scienter present, fraud can occur in two ways. We've got fraud in the execution of the contract. Now, this is going to occur when a person is deceived into signing something that they did not intend to sign. This is also something that they jokingly had on Nathan For You, where he asked someone to sign something just for the camera, but he says, "Oh, you signed this. This is an enforceable contract." I love that show. I love comedy. In this case, the contract is void. And then we've got fraud in the inducement. This occurs when the terms of a contract are materially misstated and the misrepresentation induces the other party to enter the agreement. The contract in this case would be voidable. So again, difference between void and voidable. Here, it's done. Even if you want it to continue, it doesn't matter. There's no more contract. Here, there's the option to make it void. Next up, we've got innocent misrepresentation. This occurs when a party makes a material misstatement without the intent to deceive. So there's no scienter. In this case, the contract is voidable. If I write on the contract $10,000 instead of $1,000, and I'm totally just, oh my gosh, I made a mistake, I'm sorry, that is voidable. However, we can go forward with it if we so choose. Next, duress. A contract may be illegitimate if a party enters the agreement under duress. This includes physical force. If there is physical force, it is void. If you are forcing someone to do something, saying, "I'm not going to let you out of this room until you sign the contract," thinking sort of about those timeshares. Lots of good TV show episodes about those overall, and just lots of jokes to be had about that. It sounds like something I would stay away from. If threatened by economic or social pressure, the contract is voidable. So physical force, immediately void. However, if there's other pressures, it's voidable. You can choose to get out of it. If you got to prove that, obviously something like a timeshare agreement, they just want to keep keeping you in the room to get you to sign, but you can just walk out. No one's holding a gun to your head. And then lastly, we've got undue influence. If one party abuses a position of trust or authority to persuade another party to enter into a contract, the contract is voidable due to undue influence. This would be if your boss tells you, sign this contract or sign this piece of paper that takes responsibility for the fraud I committed. Well, you're being forced to do that, so you're not going to do that. Or if anyone in a position of power forces you to do anything, that is completely undue influence, and that would be voidable. All right, a few more. Next, we've got mutual mistakes. So both parties are having a little brain fart that day, and both parties make a mistake concerning a fundamental aspect of the contract. Mutual mistakes do not apply to mistakes of value. The adversely affected party can void the contract in this case. Next up, a unilateral mistake. So generally a unilateral mistake, which is a mistake made by just one party. It's not a defense for illegitimate contracts. However, an exception exists if the other party should have known about the mistake. Not too bad, nothing crazy. Next up, illegality. If it's anything involving illegal activities or subject matter that the courts do not view that as valid, and they're immediately void. Any contracts about stolen goods, drugs, anything illegal, completely invalid. And then we've got licensing. The enforceability of a contract may depend on the type of license required. So think about if you've got a CPA license, that's what we may be talking about. Or if a party does not have a revenue-raising license, so this is a license meant to generate revenue for the government, the contract is still enforceable. However, if a party does not have a license required to protect the public, such as a license that ensures the licensee's competence or qualification, the contract is void. So in this case, if you have a license that allows you to sell food because it's proved that it's safe, that would be letter B here. So if it's meant to protect the public, great. However, if I have a contract to fish in the lake, and the lake it's not illegal to fish in the lake, you just need a license for it because obviously the government wants their fair share of money, that would be referring to letter A. So again, letter A would be, it's not particularly illegal to do the act, it's just you're not allowed to do it without a license from the government, which again, let's just say like fishing in a lake, you just need a fishing license. But letter B, selling food from a food truck without a license, that's to protect the public. So in this case, completely void. All right, now let's deal with minors, anyone under the age of 18. How does this work? Well, I would say don't do business with minors after what I've learned with all of this. If you're a store owner or something. So illegitimate contracts can also arise due to issues related to capacity, intoxication, mental incapacity, and the statute of limitations. These factors can render a contract void or voidable, and we'll talk about those as well. But let's deal with the minors first. So generally, anyone under the age of 18 lacks the capacity to enter into a contract. They can cancel or disaffirm the contract, but the other party cannot use the minor's age as a defense. So they have all the power here. Now, is this how it works in real life? I'm sure it's incredibly different, right? I remember entering into contracts under the age of 18, whether it's to work for someone or to buy something of significant value. So that's in real, this is textbook. You may have had some different experience in real life, but this is textbook. This is how we're going to learn it. A minor can cancel the contract while still a minor or within a reasonable time after turning 18. However, a contract can be ratified by failing to disaffirm within a reasonable period of time after turning 18, expressly ratifying the contract, or retaining or accepting the benefits of the contract. So in this case, if the, let's say, 17-year-old goes and buys a $300 TV on a credit card and says, I'm not paying the credit card bill, I'm not giving you money because this TV is mine, I'm 18, they try to use this. Well, if they retained the TV, they didn't give it back, then that's invalid and the contract would be ratified. So the under 18 person would have to pay for that TV. So there are protections here, but this is a protection for minors who, let's say you're not probably making the best decisions. I can't say I made the best decisions when I was under 18. Maybe I'm still not making the best decisions now. It depends on the day, I guess. Next up, we've got intoxication. Oh boy, sweet relief from reality. Well, a contract can be deemed illegitimate if the promisor's intoxication prevented them from understanding the nature and significance of their promise, and the other party was aware of the intoxication. So if you're both at the bar getting absolutely drunk and you both make an agreement on something, generally that's not going to be valid. This is definitely something you could see on the exam, and there are many other situations in excess of what we'll see here, but these are the ones you would be more likely to see on the exam. Obviously, you can't get someone intoxicated and then expect that any agreements you make with them at that point are valid. You should probably talk about it the next day once everyone sobers up. In this case, the intoxicated party may use their condition as a defense. Next up, adjudicated mental incapacity. If a contract is made after a party has been legally declared mentally incapacitated, the contract is void. And you don't have to know what would make someone mentally incapacitated. Generally, on the exam, they'll just use that they're in a coma or they've been diagnosed with some sort of mental condition and they are not mentally capable. That would be someone who's mentally incapable. Next up, statute of limitations. Parties must seek legal action within a specific time frame, which is typically 4 to 6 years from when the cause of the action occurred. So you generally have up to 4 to 6 years to go through with this. This is so the legal system is not inundated with a bunch of different contracts that people are fighting about that happened 20 years ago. Failing to pursue legal action within this period may result in the inability to enforce the contract. And then we've got here, remember I said the difference between void and voidable, super important. Here, in this case, for all of these instances, the following would make a contract void instead of voidable. So just straight up completely cancels the contract, even if one party or both parties want the contract to go through. So educated mental incapacity, illegality, even if both parties want the contract to go through, if it's illegal, doesn't matter, there's no contract there. Mutual mistake, let's say we both make a mistake and we want the contract to go through, doesn't matter, the courts won't recognize it. Obviously, if we both want it to go through, we could still probably just do it anyway, but the courts would not be on our side here. Physical duress and then execution fraud. Any of these, I would memorize these, make sure you know in which cases the contract would be void instead of voidable. All right, let's deal with the statute of frauds and a few other points. So illegitimate contracts can arise also due to issues related to the statute of frauds, impossibility, accord and satisfaction, novation, we'll talk about all of these items, prevention of performance, and the parole evidence rule. Understanding these factors can help parties identify and avoid illegitimate contracts. Now, what is the statute of frauds? Certain types of contracts must be in writing in order to be enforceable. As we said, contracts don't have to be in writing. However, some of them do. and that would be marriage. Let's start off with that. You can't get married just verbally. You have to have it on paper in order for the state to recognize it. Now, if you get married in the eyes of God, that's a whole other story. You're not sending a letter up to the big man in the sky. Next up, contracts that cannot be performed within 1 year. So if it's a contract that lasts 2 years, 3 years, or a year and a day, it has to be in writing. They're not going to try to trick you up and say it's been a year and 2 days. But if it's anything over a year, it's kind of like joint ventures versus partnerships. If something's more long-term, you want to get it in writing, it's going to be more official. Anything involving land is definitely important to get in writing. We've got a lot of property records out there, so that is something to know. Contracts by executors, so anything dealing with estate, executors of estate. Contracts for the sale of goods over $500. Again, it's just if it's important enough, put it in writing. And then contracts to act as a surety. That actually ties back to our lesson on sureties. So yeah, lots of things we see in various different lessons. And there we saw how you have to have that in writing. The writing must include material terms, so anything important. And if the statute of frauds requirements are not met, the contract is unenforceable unless it has already been performed, admitted, or specifically manufactured. Let's dive into a few of those points more specifically, dealing with definitions. First off, impossibility. A contract may become illegitimate if it's impossible to perform. If I say, go get me a rock from the moon, I guess you could hijack a NASA spaceship and get there, but that's generally going to be impossible to perform. This applies if there is no other way to satisfy the contract. An increase in the cost of performance does not qualify as an impossibility. So if I have a contract that says you have to go and buy me a bag of apples, and the bag of apples goes up to $10,000. Maybe it was a $5 bag of apples. Now it's a $10,000 bag of apples. You entered into a contract, doesn't matter. You've got to go and do that. Now, if you don't have the money for it, that may be another case. But generally, just because something goes up in price doesn't mean that it's impossible. Examples include the destruction of the subject matter or death or incapacity to perform a personal service contract. If the bag of apples gets destroyed, then obviously the contract would be void. And then if someone does pass away, that also would be invalid. Accord and satisfaction. This occurs when parties substitute one contract for another, resulting in the same parties entering into a new agreement. So again, we saw this before where you don't just change the contract, you have to substitute it for another. Novation. In this case, a new party replaces an old party in the contract, which releases the old party from their obligations. So I would just be familiar with these terms. In this case, let's say I want to buy something from vendor A, but vendor A says, hey, here's vendor B instead. Do the business with vendor B. That would be novation, and that would cancel the contract. We'd have a new contract. Prevention of performance. The contract could be illegitimate if one party fails to cooperate or hinders the other party's performance. Totally makes sense as well. And then the parole evidence rule. This rule prevents parties from introducing evidence of prior or contemporaneous agreements to contradict or modify the terms of a written contract. Contemporaneous meaning happening at the same time. However, modifications made after the contract was signed are admissible. Just some terms, again, a lot of business law terms, a lot of Latin as we've seen. Just be familiar with them so you can answer them on the exam. Hey there! Are you ready to not only pass your CPA exams, but truly understand and enjoy the material while studying? I know it seems impossible, right? Especially to enjoy the material? We'll do it together. Tap into the power of CPA.examprep.ai, where we've got personalized quizzes, multiple choice questions, memorization guides, flashcards, simulations, all tailored to your learning. Our adaptive study planning puts you on the fastest path to success and lifts you back up if you fall behind. Avoid wasting your precious time and money attempting an exam with a low chance of passing, because who wants that? We want to get you through this process as quick as possible. Our exam readiness prediction lets you walk in with confidence, knowing that you're prepared for success on exam day. Thankfully, there's no payment method needed to get started, so why don't you come join us? Visit cpa.examprep.ai and let's achieve your exam success together.